SCORE has been around for over 50 years and has served as America's premier source of free and confidential business mentoring and education. As a resource partner of the U.S. Small Business Administration, which is the SBA, SCORE has helped more than 11 million entrepreneurs through mentoring, workshops, and educational resources. SCORE also has over 300 chapters nationwide with a wealth of knowledge and experience to share and help you succeed in business. You can go to greaterrochester.score.org to learn more, sign up for a mentor, sign up for workshops, whatever meets your needs, resources, etc. So that brings us to Brett. I'd like to introduce Brett. He's Brett Farrow. He's a founding member of the law offices of Pullano and Farrow, and he provides counseling in a variety of healthcare and general business issues. He has counseled and advised corporate and business clients in a variety of industries on the intricacy of startup, growth, mergers, and acquisitions. This experience spans corporate governance issues in both for-profit and nonprofit organizations. He has a unique experience in handling the specialized needs of highly regulated healthcare providers, in forming and organizing business and professional entities, owning and managing medical practices, advising clients on professional licensure issues, and providing regulatory compliance oversight and review for institutional providers. So with that, I'd like to pass this over to Brett. Thank you very much for being our presenter today.
All right, thank you very much. I will also add that since I generally like doing talks for SCORE for a number of years, but I've always liked the interactive nature of doing them in person. This is my first webinar. I would ask that you feel free to ask questions along the way, encourage it. We've also embedded a number of polls to make this a little bit more interactive as we go. But I thought today what we would cover are the legal considerations when starting a small business, and really looking at that through the lens of, frankly, what goes on in a lawyer's mind when a new client walks in the door and they are for the first time meeting with their attorney. As I sit there with a client, what am I thinking about as I look at you? And there's actually, what I have here is a very distinct line, the line in the sand, because I actually look at the clients for both what I would call entrepreneurship and commercialization. And those are two different things. And there really is a line that separates what I will call the back house issues that are related to the formation of your entity, how the business runs, versus actually doing business. And when you go to a lawyer, I think that we have to address all of those concerns. And that's why I encourage people through SCORE and other organizations that you should get a lawyer and get accounting and other professionals as early as possible. So as part of the talk today, the first thing I'm going to address is, one, how to use a lawyer and your other advisors to make your business actually launch, improve it, have it run and function. Part of what goes into that conversation is the choice of a business entity. Also looking at, if I'm going to get into business, might I buy a business? Might I merge my business with somebody else? Another issue that's very common for startup business or a business that's looking to take their growth to the next level is financing. How am I going to do that? I also always encourage businesses, and when we started our business in 2013, from the very first instance, we started to think about succession planning. How am I going to get out of this once I've gotten into it? All of those are really the things behind the scenes that customers don't see, that you still have to function and deal with in order to make your business successful. Then come the things that the public will see: contracts, employees, your actual intellectual property, be it your logo, your trademark, your brand, the things that people recognize you in the marketplace for. And those are all separate business issues that, as an attorney, when you walk in the door, I start to think about. So as we move forward, this is a pretty complicated issue or series of issues. Really, what I find starts to happen for people who are looking to be entrepreneurs is you get what's called analysis paralysis, and you have to try to avoid stagnation, which often comes from people not really knowing and how to understand using a lawyer and the other advisors. So the goal here is to have a brief conversation on demystifying what a lawyer does and frankly what other advisors do. First thing to know about going to a lawyer. What is the lawyer actually selling and what are you looking to buy? Most often people show up in our office looking for answers, expertise, knowledge. I think the most surprising thing that most clients don't realize about their lawyers is what I have been trained for 16 years to sell is actually a relationship. I will try to spend the time getting to know you, your business, what your goals are, what your dreams are, what your thoughts are about 5 years down the road. Because in doing so, I'm actually better able to handle both the above the line and below the line problems. And I think you also have to look at step 2, understanding what kind of lawyer you're speaking with. If you are going to enter into a contract for a music industry licensing arrangement, while you may have a friend or a neighbor that is a divorce attorney, that might not be the best person to go to in the initial phase. Now, lawyers, we do have ethical obligations where we are required to make sure that we can competently advise a client, and we may spend quite a bit of time working on your matter. And that can be surprising for a client sometimes based on what they get as a bill after the fact. You got to remember, our unit of measure for what we are selling is actually time. So the more time that we are spending on your file, that's time not spent on somebody else's file, and that therefore equates out to a higher bill. So making sure you know what the attorney's expertise is, the knowledge, building that relationship with the lawyer and knowing that they are the right person to work on your matter actually leads to number 3 being a little less painful. Because the number one thing that I think that lawyers end up having is a conversation around our water cooler is the number of times that a client will come in and say, this situation is really simple. Whatever this project is, I just need a brief insert project. The time frame that they have is very short. Because why? Well, I believe that my project is simple and therefore this shouldn't take you that long, which means this shouldn't cost that much. And really all I want is a short document with all of that quote unquote boilerplate / legalese. So critical thing to think about when you go to the lawyers, one, you have to find somebody that's going to actually have a relationship with you, you're going to feel comfortable with, and you're going to listen to them as they have some difficult conversations with you to think about your business in a way that perhaps you haven't already. The other thing to know is that all of that boilerplate and legalese is probably not there actually for you as the business owner, or even as it relates to the person that you're contracting with, if it's the post-entity formation and actually business operation side of the below the line, above the line discussion. That language is actually there for a judge. It is there to make sure that this contract that we have prepared on your behalf is actually going to hold up to judicial scrutiny. And therefore, we've included this language that we know has to be there if one of our colleagues in the litigation realm is going to make your contract stick. Going to a lawyer to get a short document that's not actually going to hold up in a court of law is probably not a good use of your limited financial resources for spending on legal spend.
Brett, this is Kristen. I have a quick
Sure.
question. We did the poll on what kind of business you're in, or if you are. I'm going to share the results of those real quick so you can see who we have. And then we have a quick poll after that. So these are the results of the first poll that we took. So you have an idea of who's in business and who isn't, and who's planning on starting one.
Okay.
And I launch a second poll in a moment.
Yep. find out what entities people have actually chosen. So for those who are already in business, presumably you may have an entity that you've already selected. For those of you who are not currently in business and are going to be looking to enter into business in the next year or so, I'd like you to see if you can answer these questions, because it helps me design what we're going to talk about next a little bit more on your reality. So the choice of an entity for clients is usually what causes them to walk in the door. Either people have read some articles online, they've spent some time talking to a friend, they have in their mind a perception of what would be the right thing for them. And I often caution clients when they walk in the door that maybe we need to have a fully vetted conversation on why did you get to the answer that you had? And really, what have you been doing all along? Because my experience is that very often people have been conducting business before having this choice of entity discussion. And we have to address that and what we're going to put into place afterwards. Selecting a proper entity not only ensures your current success, it looks like we have a mixture of a few things here today. The current success of your new business, but selecting the wrong form can contribute to its failures. What does that mean? So long-term, if you have selected an entity that does not take into account your goal of growing the business by adding business partners in a way that allows you to do it how you have imagined it, then you might end up either with tax challenges, additional costs, additional expenses, or just not being able to function and do business the way that you wanted. So I always recommend that before you go into forming an entity, understand what you're building is the basic framework upon which your entire business life is going to exist going forward. The first concept of, because we skipped too far forward. The first concept most people get into is a sole proprietorship. And really, what is a sole proprietorship? For those of you out there with the DBA, you are functioning right now as a sole proprietorship. It's the simplest form of legal organization. It's just you. There's no real special filings required. Very often what people will do is they will go down to Monroe County or whatever county you may be in, and you will file for a DBA. What is a DBA? Doing business as. It's really just an alias. It's no different than if instead of calling myself Brett Farrow, I wanted to be Al Capone, or I said my name was Scarface. So your DBA sits there letting people know in the community that Brett Farrow is not doing business as himself, but through this other alternative name. And it's really meant to allow lawyers to track you down so that if you have harmed somebody in the public, we know how to find you in order to actually commence a lawsuit. Monroe County is really helpful because you do not want to use, as we will get to later, the branding and trademark concept. You don't want to use somebody else's already taken name. Monroe County, through this database here, you can actually search for up to 70 years worth of records on names that have already been taken, names that have been used. Other counties do offer this. Some counties do not. If you're in one of those counties that does not, very often your only option is to go to the county clerk's office and come and check for conflicts, which can be a little bit more time consuming. But as we can get into later, it can save you a lot of money when it comes time for trademark and being known in the community as a business. The sort of summary of a sole proprietorship is who runs a sole proprietorship? You do. You're the business owner. You own it. You control it. You have the sole right to the profits and all of the losses. If you have a side business and you incur a loss during a year, you have a regular daytime job, which is a very common thing for many small entrepreneurs, you can offset your loss against your personal income. The downsides, though, in particular, is what that next bullet is for liability. Unlimited personal liability. What does that mean? Well, That is your home, your car, your personal bank accounts, anything and everything you own has really been put on the table for the liability. Some people are more risk adverse. Other people are willing to take that risk and function quite a while as a sole proprietorship. Long term, what is hard is if you have built up a name and a brand and a business around yourself, you can't really sell you. So what are you selling if you go to transfer this, or if you were to pass away as part of your succession planning? Again, as I said, when you walk in the door to an attorney's office, what we're thinking about is not just getting you formed, but also counseling, guiding you on how do I get rid of this business once the day does arrive. So we're thinking about birth to death of the company, or how do I perpetuate it on a going forward basis? The next thing that I didn't see a lot of people joined into, but you can often accidentally get into, is if two people come together, they may have accidentally formed a general partnership. Now, under New York State Partnership Law, Section 10, you can see that you're supposed to go and file for that association. A partnership is slightly different. If you have two sole proprietors come together, the partnership itself is treated as though it is a separate legal entity. So if the partnership comes together, you accidentally hurt somebody with your product or in the course of doing your business, what assets are on the table first before your personal assets are the assets of the partnership. Why do people form these? Again, they're usually quite simple. They're quite inexpensive. You can go down to the county clerk's office. You're up and running quite quickly. Unfortunately, general partnerships are not required to have a partnership agreement. The best way that I can describe a partnership agreement is that it is sort of like the prenuptial agreement for two people getting into a business financial marriage. If you are going to be married, those relationships that are founded on love often get torn apart over money. When you get into business, the number one reason to get into business together is for money. Divorces can be very brutal and very costly and tough to go through. Partnership divorces are equally as bad, if not sometimes worse. So what we always encourage people to think about is what would go into how that we come together, what are our rights, what are our responsibilities, how much time are each one of us going to contribute, what's going to happen if this doesn't work out, how are we going to dissolve this, who's going to get what assets, where does the money go, where do the physical property assets go. And looking at the characteristics in a general partnership, both partners or multiple partners, if you have 6 partners, each one of them, unless you have a management document that says otherwise, have co-equal authority to do anything on behalf of the business. Partners will share equally profits and losses, again, unless the partnership agreement specifies otherwise. Why might you want that? If you enter into business with, say, a relative, that relative really is only working part of the time, and the person who's working there all of the time, they want to make most of their daily living off of this business. Well, you're going to want to dictate that the money is distributed differently than 50-50. Only one of you is working there all of the time. The biggest risk, though, in a general partnership is what's in the last bucket, the liability bucket. So partners are jointly and severally personally liable for all debts and obligations of the partnership. For a lawyer, those are the things that send chills up and down a transactional attorney's spine. Joint and several liability means that whatever your partner does, even though you were not there at the time they did it, whether they entered into a contract, they harmed somebody, etc., your assets, your personal wealth is actually on the line and responsible for what that other person did. So it's very important when you get into a general partnership that you really understand the business that you're getting into. You can mitigate this to some extent with a partnership agreement, but if you don't have that, you should understand what your risks are. A much more rare thing these days are both the limited partnership, which is a specific type of entity you have to have a document for. Really, what this is meant for is the, let's say in this context, a wealthy aunt or uncle who has deep pockets and wants to help you get started. They're going to contribute money, but they don't want this awful joint and several liability. They heard that Brett Farrow guy talk about at SCORE. So they will ask to become a limited partner. A limited partner has to have limitations on what they can do. All of that has to be set out in the limited partnership agreement. Because you're buying for somebody a limitation on how much liability they have, you'll notice that the cost went up. It's now going to cost you about $450 because for every layer of protection, sort of like buying an insurance policy, you are essentially going to pay more. In the partnership agreements, you want to make sure you're handling dispute resolution, how the company ends up being dissolved, who has the authority to bring in new partners, who has the authority to sell, and any restrictions on business activities of the partners while the business is ongoing. If you have two people who on the side are also doing the same business, everybody's making a bakery business and both parties on the side also continue to do a baking business, that really hurts the partnership. So you want to make sure that that's not happening. Because this isn't a very common structure, I mean, we'll run through this quickly, but the profits and losses get divided in a limited partnership according to the partnership agreement. The liability of the partners, the general partners retaining that unlimited liability to the third partner, and for that extra expense, the limited partner has bought themselves a limitation to only the capital that they invested. So if rich aunt or uncle puts in $100, they are only liable for $100, even if the actual expense of the liability is $100,000.
Brett,
Limited. Yep.
Brett, we have a question.
Sure.
And the question was, how can you sell goodwill if you cannot sell the DBA?
So goodwill we can come to later, which is more tied to what you will see with corps and LLCs. Very often accountants will try to help prepare goodwill as a concept in the sole proprietorship role, but you're always running the risk of what you're selling doesn't actually exist. So we will often have to do additional things like trademarks, logos, branding, trying to identify physical assets that you can actually sell and transfer. That's how you're encapsulating that goodwill. The problem if you don't do that is that it is possible that the Internal Revenue Service or New York State Sales Tax Department would say that really what this was a sale of assets for a premium. There was no goodwill because this was a sole proprietorship. And I therefore think that the 50-year-old desk that you sold is actually worth $10,000. You would then have to fight that. I'm not saying that that would actually hold up. The problem would be because what you tried to sell was a thing that was not intended for that, you're going to incur additional costs potentially that you weren't anticipating.
Okay, great. And so if they want to exit the sole proprietorship, can they sell the DBA?
You're not really selling the DBA. You could sell the right to the name. Very often licensed providers might be a sole proprietorship that has gotten a DBA. Dentists do it very often, but it is more difficult to value a company like that and to provide a justifiable reason for the expense of the business. Not that it can't be done, but you're doing it with more risk. And for what I would say is a relatively small fee in the grand scheme, it is a much easier and smoother transaction with less likelihood of a problem later to do something a little bit different.
Awesome. And one last question. This person has a bakery business and she currently has her kitchen certified. What is the best business entity to set up for that business? Is a DBA okay to start?
Most businesses will often start as the DBA, but I also don't want her to steal my thunder by getting rid of what's coming in the next couple slides. So I think we'll end up answering that sort of by going through the rest of this entity choice selection process.
Perfect.
I hope you'll bear with me. Limited liability partnerships. I think that I heard that there were a couple, perhaps accountants or others on the line today. Limited liability partnerships really are meant for licensed professionals. Lawyers are very often, older law firms set it as limited liability partnerships. If you are a licensed professional, this is the thing to go to for you. So now we get into corporations and limited liability companies. These are the things that most people that come to a lawyer, they're like, all right, I've been doing business for a while. Maybe I want to have this corporation. What are the benefits? I've heard about S Corps. I've heard about C Corps. What is all of this? The benefit of a corporation is that it's really a separate legal entity. It's like going out and buying stock on the stock exchange. Once you have bought it, the only amount of money that you have at issue is that which you invested to buy that stock. It's not like if the company that you invested in goes bankrupt, that they come back to you as the individual shareholder and seek money to make the company whole. And that's the benefit of the corporation. It's that legal shell. The hard part of corporations is that the business corporation law in New York gives you a bunch of rules. If you're not going to follow the rules, then the law states, why should we give you the benefit of the corporate shell? You're getting a benefit as long as you follow the rules. And so there's a legal theory called piercing the corporate veil that can be instituted if you're not following those rules, like having a board of directors, having officers, having shareholder meetings. And this is hard for small business owners when you get started, because you're like, well, who the heck would I have a meeting with? Yourself. It is a corporate formality, and for some it seems a little strange, but we do assist clients in going through this process and making sure that you're keeping those formalities up to date. Corporations are really beneficial too for being creative on how you can invest in them. There can be capital structure means, do I have one class of stock? Do I have preferred classes of stock? These are common things in the marketplace that people may have heard thrown around in movies or who knows where, but those have very specific rights tied to them. So if you're a person looking for that silent investor, a corporation might be beneficial if you're a C Corp versus the S Corp, because the C Corp allows you to have multiple classes of stock. Now it's got a major detraction to it that we'll get to in a minute, but the S Corp is what a lot of small businesses will create, because it does not have this problem, taxation. C corporations run the risk of having double taxation, meaning for every dollar that is made by the company, the federal government and New York State in this instance will have a tax that they want to get a portion of those funds. For once you make the S election, which is a federal form, made that election, and for purposes of making that dollar, the government will disregard that entity so that the only layer at which they will tax people is at the employee or the share distribution, the dividend that you're paying out. So why aren't all corporations just S Corps? I mean, why would they want to pay the expenditure of this additional taxation? Well, S Corps are limited to only one class of stock. There can only be up to 100 shareholders. There can't be any foreign shareholders. So it's really a much more non-flexible form of business entity that, as the woman who asked about the bakery, I don't really know what your 5 or 10-year plan is, where investors may be coming from, things of that nature. So if you could, you might want the S-elected corporation. Maybe you would want the general C corporation. A lot of that's going to be factually specific to her situation, where she is today and where she's going. Benefits, though, quickly running back through them, limited personal liability, easy to raise capital. This is what most, publicly traded companies are. Centralized management. It's easy to understand who's in control, who has authority. You can limit that authority. It's not like the company dies because the founder dies. It's easier to transfer shares, sold publicly. You can go today to NASDAQ, buy some stock, you're buying a company. And you can also put in place pension and welfare benefit plans with a corporation that may allow you to maximize savings as part of your own succession plan. So those are things to think about. The downside are the double taxation, the formalized structure, and to be fair, there is a high maintenance cost ongoing just in terms of filing of separate tax returns, et cetera. Again, this is why having a group of advisors around you makes this business structure work a lot more seamlessly. The most new and fancy version, which lawyers in particularly love, but accountants do help us to rationalize that from time to time, is the limited liability company. I say they're new. So really, prior to October 24th, 1994, this business structure didn't exist. So what was it that spawned legislatures across the country to form limited liability companies? Well, we wanted to make sure we could take the flexibility of a partnership and put over the top of it the protection of the corporate shell. In doing so, we created, without really getting too creative about the naming, the limited liability company. The cost of it, if you just look at the expense, about $450, you do have to have an operating agreement. Really what that is going back to what we talked about in the partnership agreement. It's setting out the rights, responsibilities, it tells the world who has what rights. Management, that can get quite creative. Again, it's why lawyers like it. We can have it be managed by the actual owners, sort of like the general partnership. We could have it managed by a group of managers, sort of like a corporation. We get to pick what we want, and we can change it after we've actually picked it a little bit more easily. You can put a lot of rights into the operating agreement. You can restrict rights within the operating agreement. When it comes to profit and losses, unlike in the corporation, where if everybody owns a share and you're all in the same class of shares, you all have to get the same dividend payout because you all own a class of shares. In an LLC, we can change that. We can tweak it. We can cause the payments to be more closely related to what you would see in a partnership. Liability, very nice. You can also protect your liability from that joint and several or personal liability that we got with the general partnership, closer to what we saw with the corporation. This is just a recap of all of those advantages and disadvantages. Because I know that we have a lot of other topics, I'm going to continue to move on because this is only still one of the actual concepts that goes into it. But at this point, I'm going to see if there's any other questions.
Yep, we have a question about how much time do I have to publish my LLC?
Well, technically, you're supposed to start publication like right as you get started. The law does provide for a couple of time frames, including getting your operating agreement in place 90 days after. The state could say that you are not in compliance and they would therefore deactivate your entity. Typically speaking, though, if we find a client who has not completed their publications, what we do is we just get that, we actually file it, bring it back up into compliance, and the state will usually reactivate those entities.
Okay, thank you. That's it for right now.
Perfect. So we've got another poll, I think, that will go up about people who have considered buying a business as the way to get into business versus starting the thing from scratch. So we'll let everybody make their choice. But I guess, for lawyers and what I do, mergers and acquisitions are probably one of the most fun things to do. It's a little bit like being in the Roman Empire. They are not for the faint of heart. It is a lot more work sometimes than a person really anticipates. First hard part is finding an acquisition target. There is a world of business brokers and others out there that will help you sometimes do that. If you are a seller, you might go to one of them because you're not sure how to sell your business. If you're looking for one, you might go to one of them to buy one. The hard part is actually setting out the terms of that relationship. Is this going to be an asset deal? Is this going to be a stock deal? In the asset context is when we get into those conversations about goodwill. Because if I've got, my law firm, if I were to sell the assets, what is the real value of buying the desks and the old computers that we have, because technology changes so rapidly. There's a few people looking to talk about M&A, so we will continue to spend a little more time on this. The difference between an asset and a stock deal too goes to the liabilities. There is a lot more liability that comes with taking on the corporate shell. And you really want to spend some time in what's called due diligence, making sure that you kick the tires and understand what's going on. Then there's really complicated question about what are we retaining? If I'm buying the assets, do I have certain liabilities come through to me? Do I take on your accounts receivables? Do I pay you dollar for dollar as an acquirer for the accounts receivable when you are experiencing typically an 80%, bad debt? In other words, for every dollar, you're only collecting 80 cents. Why would I pay you $1 for that AR? It's hard to calculate all of that. What does all of this cost to buy the business? Well, it can be fast, but usually if it's fast, it's because you have paid a group of people to come and assist you to get through this process, and they have dropped everything else and are only focused on you, which means it's often costly. If you do it fast and you don't spend the time making sure you understand, it's often costly because you may have taken on a risk that you didn't understand, you did not know. As my wife would usually say, it's not a matter of a question, can you afford to have the time? It's a matter of a question, can you afford not to spend the time? The capital that is involved is not just the money, it's the legal and accounting time and the money that you're spending on them, and identifying the right team, which usually involves getting with your bank early, getting with an accountant, getting with a lawyer. The earlier you get that team assembled, the better off. And to assist clients when they are looking at doing mergers and acquisitions, in our office, we tried to provide some sort of framework for people to think about. These phases are, I think, a little more fluid than they would look like on a piece of paper, but I think it helps clients to understand what's coming next, be prepared for it, manage that expectation, understand what they have to think about in terms of the workflow. And we've broken it down into these 4 separate acquisition phases. The goal of your attorney in this is to make sure that what you're getting is what you're expecting to get, and that the seller, you're actually getting the compensation that you would be imagined. When you buy a business, the benefit that you get is that the business already has goodwill. It's got a customer base. It's got efficiency, public acceptance. You want to make sure you understand all of that. Hopefully it's already cash flowing and profitable. If that's the case, then it's really easy to walk in and see how you're going to pay that off. Disadvantages are, if you do this incorrectly, you may not actually know whether or not the business does have goodwill. Maybe the reputation is much worse than you anticipated. And that's why you want to spend the time in that phase 2 due diligence. Does anybody have any questions on buying a business?
No, we are clear.
All right. So we're still not even through all the things we think about when you walk in the door just to get your business up and running. Still have to talk about how do you finance the business. So there are a number of different options. There's a poll that's up letting us know what you're thinking about. But basically, when we look and you walk in the door to start talking about financing your startup or financing the next phase of growth, we have to start looking at tax planning. How do the tax planning aspects that you may be working on for the company and for you individually impact your ability to go out and get bank financing, let's say? As we talked about the C corporation, if you have a C Corp, to avoid double taxation, many people will do what's called zeroing out the books at the end of the year. If you do that for about 10 years, it is very hard to go out, frankly, any one year, go out to a bank and show them your balance sheet, your profit and loss statement, and it constantly shows that you make no money. Banks are really reticent to offer financing to a business that doesn't make any money. So that's something to think about in sort of the interplay between tax planning and financing. Looks like most people are going to look at funding this themselves. So that might be either taking on debt for them personally, home equity lines, whatever, or eventually going off and getting a bank loan. Loans and legal opinions from banks, they can have an extra added cost. It's sort of like when you go to get a house, you go to get a mortgage, there's usually a lawyer involved that is counseling and advising you on what's involved in that mortgage. Well, when you get a bank business loan, very often the bank wants to make sure that certain facts about you are actually true. And they ask your lawyer to sort of sign on in a way to your loan. So in order to comply with that, we have a process that we have to go through, and that's called a legal opinion process. That adds additional cost, just like going to a bank to get a mortgage adds additional cost. Those extra fees that are always involved, the extra costs involved. Does anybody have any questions specifically on the areas of finance?
None that they've put in the Q&A yet. Oh, wait, I do have one. They just popped up. Does self-financing a business, which is an LLC, does that pierce the corporate veil?
No, when you put the money into the LLC, it's now become an asset of the LLC. That's sort of your capital infusion. It would be like going off and buying stock of General Electric. The key is to make sure that that money is kept separate in a separate bank account and that you are not commingling or intermingling the funds.
Okay. And do you have any tips about crowdfunding for a new business, like on Kickstarter?
Crowdfunding gets into a really fun world of SEC compliance and things like that. Private equity, it's like a form of fun entrepreneurial venture capital. I would say that you really want to make sure that you understand what your risks and liabilities are. I think that is a discussion wholly unto a separate, at least 1 hour conversation. And if you are considering that, I would definitely recommend that you get legal counsel involved, as well as have that team of trusted advisors and professionals like an accountant, like your banker, because that is a great way to generate capital, but comes with a lot of unique pitfalls.
Okay. And the only other question is just a generic question. Are you going to be addressing selling a business coming up?
So in the selling process, I mean, it's sort of the reverse as of the acquisition process. If you're looking to sell your company, what you want to make sure is that you're trying to cut off those liabilities. So where in the acquisition phase, you're trying to make sure that you understand what liabilities exist. When you're the seller, you want to cash out, get paid, and then in a very short, if not immediate time frame, eliminate all of your lingering risk. Risk for what? The employees that you had, contracts that existed, your Time Warner Cable internet contract, your Culligan water guy who delivered the water, the snowplow contract, the real property, all of that you want to terminate so that you don't have those lingering afterwards. And that's why it's important to get somebody involved early who helps you really organize all of that. It's really easy to forget some of those things when you're selling the business. You're focused on the buyout, that dollar amount. And these lingering things are often the ones that leave you with a very bad taste in your mouth.
What about the due diligence on the part of the buyer?
So if you're doing an asset deal, you should really spend a good amount of time. If you're doing a stock deal, you should spend a lot of time. In the stock transactional phase, you're literally stepping into the shoes of that company. There's no time frame where that company is going to cease to exist. You have acquired it. So if it has any skeletons in the closet, you're picking them up. So due diligence is, again, dependent on what it is that you're buying, what's reasonable in time and scope, and how much you are spending, and how much risk the buyer is willing to take. If you get a deal for a very low cost, you think that the business is worth $1 million and they're going to sell it to you for 500,000, are you willing to maybe take some additional risk? And the answer is probably yes. A lot of that comes up as you're meeting with your counselors in terms of, what am I looking at? What's the deal?
Okay. And how do you determine whether the buyer can actually pay you?
So there's ways, you might say that I want to make sure that I'm getting paid at closing. You want, as a contingency to closing, that they've got bank financing. You want to see proof of that. A lot of that goes to, how are you going to fund the buyout? If it's an earnout, really what they're using is the money generated by the business to pay you back. So it's hard to say there's one way to figure that out. A lot of that is tied to, how am I structuring the deal? Again, the best way to figure all of that out is to go and get a team of people around you who are assisting and taking that burden with you. If you try to do it all on your own, there's a lot. We still haven't even covered all of the things just to think about when you walk in the door. And this is just one of those things. So it's a complicated structure. That's why a lot of people get into analysis paralysis.
Right. Absolutely. And I think that wraps it up for the questions at this point, Brett.
So the other phase that we often talk about, which seems odd, especially to young business entrepreneurs, is succession planning. Like, why am I having the conversation about how to get out? And for those of you who are looking to sell, these are things that you should take into account. And one of those, which is in the poll, is, do you have a will? You also want to make sure that as part of your succession planning that you do with your business, that your will itself does not actually conflict with what you've put into your business agreements. I often find that for those who are looking to have succession planning, what they start to think about is a sale or a closure, and they don't really take into account, if I start to fade out a little bit because I start liking to go fishing, which is my personal habit and problem, then what ends up happening is you start to have your revenue trickle off. Anybody buying wants to see at least 3 years of financials, and you're actually selling at a low point. You might have to sell a little bit earlier than you anticipated, and making the right determination on that looks at both estate and tax considerations. It looks at insurance. It looks at how to fund the buyout. It looks at financial planning. I mean, if you build a business around you and you have made no investments in 401ks or anything like that, and you just sunk everything back into the business, it becomes really hard for you to get out of this thing in any other fashion besides sale, because you've invested everything into that business. So from day one, if you start building the business with the idea of how to get out of it, you can structure your life in a way that allows you to smoothly transition out without being overly stressed, whether it's to the next generation, whether it's, I'm just going to close the lights off and close the door, I'm going to lock it, that's the end of it, I built for myself a job. You have to build the business from day one to accomplish that, including a sale. If the business cannot function without you, there are very few people who would be interested in buying it. And sometimes business owners don't even see it when they've structured the business that way. And that's why counselors and advisors come in to help them with that. These are all the things that I call entrepreneurship. This is all the above the line. This is not even the commercialization aspect of running your business. So all of the things that we have talked about as you walk in our door, these are the things that are running through my head, just in terms of how your business will get up, will get running, how do we get out of it? Am I going to have a variety of things? And I haven't even thought about what it is that you're providing out there to the world for commercialization and actually the sale of a product. Does anybody have any questions on the things that we've covered so far?
Nope. Everything's clear right now.
All right. So now we're going to talk about, oh, we've got
Wait,
one.
yeah, we did have one just popped up. Is it advisable to dissolve a DBA that you no longer need or use?
It would be nice because if somebody else would like it, it would be easier for them to obtain it in the future. If you keep the DBA to yourself, then technically the other person they shouldn't use it. They can't use it. If you're not going to do anything with it, leaving it on the books seems unnecessary.
Okay. And we're clear for now.
One of the things that clients who've been in business for a little while come in to talk about contracts. And so I know we have a poll that's out there a little bit on contracts and contract forms. And one of the biggest issues that people have is, whose contract do I use? For lawyers, that's called the battle of forms, yours versus theirs. If you are a sophisticated business, you will notice that if you go to enter into a contract with, say, a local large business, or pick one, Wegmans, the Wegmans form of contract is very consistent and they don't budge off of it very much. There's a reason for that. They have a lot of contracts. The more contracts that you have to try to enforce, if they're all different, it costs you a lot more to go off and actually defend them, to enforce your rights under them. So that contractual consistency, making sure that you're using yours, you understand it, and that you have a good process where you don't use the last version of a contract that you put in place. You use the original template contract, because the last version you've negotiated. So something's changed that you originally intended to be in there. If you forget to put that back, all that happens is, over a series of contracts over time, your actual form is now, eroded to some new thing that doesn't actually protect you the way that you think you are protected because of what you thought you originally bought, this contract. So that's a process that I see that a lot of clients will struggle with, or they will want business so badly that they will highly tweak their contract, or they have no contracts at all. Defining the service too provides you with protection that somebody will show up later and claim that you didn't do what you said you were going to do. And then the biggest thing from your lawyer's perspective, which clients, whenever they come in, the thing I had to begin with was, I just want a short contract. It's a simple arrangement. It just should be a page. And then they see that the lawyer comes out and we have these things, indemnification, reps and warranties, and everybody's like, oh my goodness, what is all this? This is just overkill. It's legalese, it's boilerplate. So in addition to doing conversations for SCORE, I actually have done a number of talks to actual lawyers. So when we do continuing legal education to train lawyers on the topics covered by indemnity, reps and warranties, and lingering covenants, I teach them about this. 14 different individual concepts that we spend over an hour and a half running through with the lawyers to address these things. Again, when you look at your contract, you got to remember that it's not really just designed for you. It's not even designed just for the party on the other side that's going to enter into the contract with you. It's actually there to enforce by a judge in a court of law. And if the contract doesn't meet that third purpose, why in the world would you want to spend money and time putting the thing in place in the first place? So all that legalese, when you look at what we lawyers are talking about just on a subsection of your contract, it takes up an hour education unto itself, realize that that language is really important. Now, what I would recommend is you should spend the time with your lawyer, making sure that you understand it, because really what that goes to is risk allocation. Making sure that as part of your negotiation with a third party, you understand who's assuming what risk, and is it reasonable and fair that the two parties actually do it. At our firm, oh, I mean, we try to focus, we try to train, we call it the P&F perspective. You can't allow the liability tail to completely wag the dog, because if you're not getting the contract in place, well, that's just as meaningless. But it is important to make sure that your client actually understands what they're agreeing to, and that's often buried in that quote unquote legalese. And we are, you know, as we were talking before getting onto the call, I work at the Paragraph Factory. Working with words and manipulating those words in very precise manner is what we do. And are non-lawyers really as well trained on this quote unquote art? Probably not. I guess that's why we do what we do. Are any questions on those concepts as part of a contracting process? Because now comes the next part of what the public actually sees.
Any questions, anybody? Right now, we don't have any, but I'll bet as you go into this next topic of employees, there'll be.
It might be a few. We're covering
Yeah,
an awful lot of topics. We're moving pretty quickly at this point. But I want
absolutely.
to make sure that I give you the full perspective of what is going on in my head when a client walks in the door. Because one of the questions they always ask is, are you going to have any employees, or do you have them currently? Will you have any in a short period of time? Why? Well, one of the pitfalls that most businesses have is it's a sign of success that you are bringing on employees. But very often, if you got into business to make a widget, you did not get into business to hire people and to manage people and to train people and to make sure that you have good processes in place to hire, fire, train, manage, keep them happy, wellness programs, etc. When you look at large corporate America, there are people who go to get degrees not to make a widget, but literally to focus their entire lives on this. There are HR consultants, there are lawyers who do nothing but end up, practicing in the employment space. So for those of you who have a employee, or those of you who look at, I might have some in a year, this goes to why when you walk in the door to have that initial consultation, you should be getting asked and being forced in a way to think about, am I going to have an employee? What would it look like? What would it take? Because the employment lawyer's world is looking at things like I-9, employment eligibility verification. What questions can you reasonably ask in an interview that are not discriminatory? What issues come up from the federal equal employment law? What are the New York State equal employment laws? And those are constantly changing over the last couple of years. I mean, the number of changes has been radical. The checking of references, how do you go about that? What's likely to happen if you do call somebody? Once you have an employee, do I need a handbook? Probably the answer is yes. I can't really imagine a world where you should be having lots of employees without a handbook. How often do I have to update that? What things would trigger an update? How do I manage the update? How do I deal with paid family leave? Overtime, making sure that I'm capturing that. What's the risk? If you are not paying overtime on a regular basis and you think that you're in the business of making a widget, and now the Department of Labor is coming after you for unpaid overtime, those are the things that really sink a business that never came up prior. And if you're really successful, you get into the concept of unions, union organization. That may not be what people on this call are particularly worried about today, but if you're really growing, that is a possibility. And then in New York, we now have mandatory sexual harassment training for your employees. You have to be making sure that you're documenting that you're having that. And this is just the tip of the iceberg of employment issues. So again, looking at this, I find that business owners will often not have a process. They get to the point where they want to have a termination claim and they don't know, because the employee was doing something, a best practice for doing that. And if you get successful enough in a community, how bad can this be for your company? Well, go ask Trader Joe's. I mean, they right now are all over the news because of the way they terminated an employee and what they raised in the media. And now everybody is looking at Trader Joe's. So not working with people experienced in this realm, and that's a huge multinational corporation, and these little slip ups have immense economic realities for a business. Does anybody have any questions on what it's like to have employees, the face of your business to the outside world?
Yeah, no, there's nothing here yet.
All right. Well, the last thing I want to talk about that I'm thinking about from the minute that you walk in the door is what phase are you in, and have you started to, as most business owners have, creation of what we'll call intellectual property. You've got a logo, you've got a brand, you've got a business card, you've got something. What is the number one way to harm or negatively impact your business? It's to not recognize when you have intellectual property that you should be protecting, and then understanding how to go about protecting it. Why? So, everybody probably has seen these items. These items here are actually called facial tissue because there is a company called Kleenex. Kleenex, though, really didn't do a good job protecting its intellectual property to a large degree, not to the same extent that, say, Coca-Cola or locally here, Nick Tahoe's with the garbage plate has done. And as a result, they've really lost the ability to completely shield the use of Kleenex someplace else. A worse example of somebody failing to protect their intellectual property was aspirin. Aspirin was really a brand. It was a name. Now lots of people use it. They failed to spend the money, the energy, the effort, and the time on protecting their intellectual property. On a macro level, locally, you may have heard of some legal battles over some scripts on a certain grocery store chain's logo over in Pittsburgh. And there was another competing national corporation that uses a similar script. And they spent a lot of money getting into an argument over that. So the minute somebody walks in the door, what I'm looking to and what I'm asking you are a series of questions where I'm trying to find out, do you have any of this stuff? Do you have a patentable technology? What would be necessary to go get you that patent? Do you have logos and intellectual property that are trademarks or copyrights or things that we should go off and protect? Because if you fail to protect them, all the work, all the effort, all the diligence, all the time, the employee issues, everything else could very easily get eroded, because the fundamental thing that goes to the production of goodwill, as we go back to that concept, you have sort of lost because you've never really protected your intellectual property. And a lot of business owners fall prey to that, and it may be a little too late, and there's been some business damage, and they spend an awful lot of time and an awful lot of effort trying to rectify that. And I guess, again, I go back to, if you spend the time up front and you look at my business name, I've registered it with the state, I've registered it with the county. I'm looking to make sales across county lines. I'm looking to make sales across state lines. I'm looking to sell things on the internet. I'm looking to sell things in Canada. I'm looking to sell things in Albany. How do I protect the time, energy, effort, and the business that I have started to build? Do I need a trademark? How do I go about it? How do I recognize that I have something of value, which goes back to when I sell goodwill? Where is that goodwill coming from? It's often tied to that image, that brand. I have a Yankees problem. When people ask me, what am I probably answer a Yankees fan. So the problem for the Yankees is, how do you value the interlocking NY? And most of the people have said it's darn near priceless. I mean, it's so internationally known, and they have trademarked it. It adds value to the entity as a whole. It is, and they are very diligent in trying to protect, that image and that brand. So with that, is you walk in my door and I shake hands, or I now elbow bump, or we do a Zoom meeting or a Teams call. All of those things are what are running through my mind as I sit there and I talk about legal pitfalls, legal issues, and they're all rolling around in real time. And that's where that initial conversation and getting to know you. And that's why I say, what is a lawyer actually selling for you? In order to be able to address all of that, I can't really do that well if it's just an occasional phone call when you have a problem. A lawyer should be selling you a relationship. They should be spending time with you. You should be spending time with them. You do have to find ways, talk to your attorney, talk to your accountant on how to manage your legal spend, come up with a budget. But if you're trying to do all of this on your own, my experience is that's why most small businesses tend to not be successful long-term. When you look at businesses that are successful, I would challenge you to find ones that don't have either accounting departments, and legal departments, and marketing departments, and insurance, all of those things. That's what's making them successful. Does anybody have any other questions for me?
If you have any questions, please feel free to put them in the Q&A or the chat for Brett. Anything in particular? Brett, does your firm offer a business formation package or offer an initial business formation consultation?
Yeah, so in our office, we do our entity formations on a flat rate. So we can have that provided to you to see, what our rates are. They are, the ones that are on the sheet are tied to New York State. They do fluctuate slightly if you're going into another market due to the filing fees. Ethically, lawyers were not supposed to be fronting the filing fees for clients. So you're paying for that. But we do those. And usually when a client wants to come in, we'll spend time with them, one of the attorneys in our office, going through, the sort of gist of where you're going to be in 5 years, where you're going to be in 10 years, you're going to have employees, how do we structure that, who's your accountant, how are you filing your taxes now, what's your succession plan, will you have partners? And that helps us design what the right entity is. Personally, I still always ask, can you get your accountant to participate in that call or that meeting? The reason is you do not want to have the two counselors going in opposing views. And what you may have told the lawyer could be different than what you've talked to the accountant about. And we are looking at the world with two different lenses. And getting us on the same page helps to make, the actual client's life easier.
And do you offer an initial consult or a free consultation?
We do, have an initial consultation where people will call and we'll sit down with one of the lawyers in the office. So we do have, it depends on, what they're calling about. Usually the first calls that we have with a client are about learning about them and what their needs are. I guess if somebody was calling to get exactly what they should do, I'm not sure that that's always what they would get as a result of that initial call. We regularly take initial calls to the office to talk about issues, and those are non-billable usually.
Okay. Great. Any other questions, everybody? Okay, well, you've got Brett's contact information if anything comes up for you after you've left this presentation. Brett is easily accessible. He is always friendly, and it's always great to have him do our presentations. Thank you very much, Brett. We appreciate that. And thank you to everyone who was attending. And also, if you need a mentor, if you'd like to go over things with a mentor, visit our website at greaterrochester.score.org and click find a mentor and put in your zip code and somebody will be matched up to you. Thank you very much for attending. And Brett, thank you very much for presenting.
Thank you. Have a good day.